All rise. The Court of Appeals Division 1 is now in session.
We're flipped. So I need to flip that in case.
Oh.
Nope. I can't reach it. I can't reach it. Can you reach it?
Here, we'll just switch sides.
Aaron, will you come
Yes.
fix this, please?
Oh. Please be seated.
Yeah.
Welcome. We are here today in our case number CV19 0439, NSF Inc. Versus Miller. Counsel, you'll each have 20 minutes for your argument. You can reserve time for rebuttal, but you got to do that yourself. There's a clock for that purpose at the podium. And please introduce yourself and your client when you begin argument, because we are audio and videotaping this proceeding. And with that, let's get going. Thanks.
Thank you, Your Honor. May it please the court, my name is Nathan Ryan with the law firm of Holden and Armour, and I represent appellant defendants Aaron and Lisa Miller. The question presented in the appeal is whether Arizona courts have meant what they said regarding that there is a strong preference for cases to be tried on the merits. What the Millers are asking for is a chance to go through the normal process of litigation, nothing more and nothing less.
Counsel, is this a default judgment?
This is not a default judgment, Your Honor.
So, in other words, the court did take it up on its merits, right? It did consider the summary judgment motion on its merits.
Your Honor, the way that this case proceeded, the answer was filed, and then a motion for summary judgment was filed a month later. There's no discovery, no disclosure, and unfortunately, given the facts of this case, specifically the actions of prior counsel, this case was not decided on the merits. While the actual motion was a motion for summary judgment, based on how the case actually proceeded, it was really a default judgment. And the reason why is because prior counsel did not enter a notice of appearance. They told the Millers that this would give them a strategic advantage to delay the case, improper on its own, and questionable at best, as this case showed. Then he ghostwrote all the...
Do you disagree with the characterization that the answer that was filed essentially agreed with liability? I mean, did it...
No, I don't disagree with that. I feel that that was the basis for the motion for summary judgment, and it was based on the flagrant misconduct of prior counsel. I believe that he did nothing to advocate for his clients, which is the bedrock of our legal system.
But again, drawing it back to your opening, you're saying that this case was not taken up on its merits, and what the court had before it at the time of the summary judgment hearing was an answer that agreed with liability, and the court took up liability. I guess I'm failing to see how, although the procedural trajectory may not have been what would have occurred in a traditional case, how this was not on the merits.
It was not on the merits because prior counsel never should have admitted liability. Prior counsel never should have agreed to the motion for summary judgment, essentially, instead of performing discovery and disclosure and the normal process of litigation. Instead, through his actions, there was a $340,000 judgment against my clients that really they had no opportunity to dispute in any way. Instead, they did what we as members of the state bar always preach. We preach, get a lawyer, trust your lawyer. Your
But
lawyer
they didn't
is...
get a lawyer. Their lawyer never made an appearance, and other than the affidavit, which was filed only in a reply brief, which I find troubling, have offered nothing to corroborate this existence of this lawyer, the fact of any of the communications that they allege to have occurred. My mind boggles at the way this case has been handled, not only below, but even in moving to set aside the judgment. I mean, if they need to sue this guy for malpractice if this really happened the way they said it did.
Sure, and that absolutely is true.
Then why are they trying to protect him now?
Well,
I mean, you even referenced that in your brief. Well, because there's ongoing litigation in the bankruptcy, we don't want to. I just find it inconceivable.
I find the actions of prior counsel inconceivable. My clients felt that there was a relationship to preserve. They haven't said his name. However, if it was up to me, yes, I believe that this attorney should be held accountable. It's inconceivable to me. As for the legal malpractice portion, William Penn said that justice delayed is justice denied. They could go through a legal malpractice claim, and that would be a very high burden for them. They'd have to prove the underlying, not only the misconduct of the attorney, but the underlying litigation, that they would be successful. Right. That's very hard to do when there is no discovery or disclosure.
Counsel, the courts have rules and deadlines, and we hew towards efficiency. And so if a party hasn't complied with those rules and deadlines, I think the burden is on that party to prove that whatever circumstances are needed, whether to set aside or not, are present. And if they can't, then pursue other alternatives, which here would be a malpractice claim for the amount of whatever is in dispute in this lawsuit. I mean, what are the reasons that we should sort of rewind this case, other than the incompetence of a lawyer who is sort of vaguely referenced, but I mean, we don't see a fee agreement, or we don't have much to go on with regard to him. What is there? Why do we rewind this, other than the incompetence of I don't know if he's unnamed or not, but a lawyer who is sort of generally referenced in an affidavit?
The bankruptcy attorney, according to the affidavits and the actions in the affidavit, which are undisputed, and just going back to Your Honor's point, Rule 7.1 does allow for affidavits and attachments to affidavits to be filed with the reply brief. But based on those allegations, and this was more than just misconduct. This was gross misconduct, and there has been no litigation. There was no discovery. There was no disclosure. This case was essentially decided before it even began based on the flagrant misconduct of this prior attorney. And the actions described in the affidavit are absolutely wrong. They shouldn't have happened. And really, today is a decision between deciding a case on the merits and doing what's just for parties who were wronged by a member of the state bar, or letting this wrongfully got judgment, not based on opposing counsel, but on the prior counsel, stand.
Counsel,
or it's about.
Okay, you're up here for on appeal from a request for relief under Rules 59 and 60. Let's tie this to those rules.
Sure.
Legally, under Rules 59 and 60, under the standards applicable to this court and this venue, what is your legal argument?
Under Rule 59, any irregularity can be the basis for a new trial if that irregularity deprived the party of a fair trial. And in this case, there was a significant irregularity based on the conduct of prior counsel, which warrants a new trial.
The trial court disagreed with you on that. We review that for an abuse of discretion. Is that correct?
That is correct. And the first issue that is up on appeal is that the trial court did not consider the affidavits based on the minute entry that the trial court submitted. Now, appellants would request that the court instruct the trial court to consider those affidavits and do an analysis under Rule 59 and Rule 60 so that
the trial court was clearly aware of the affidavit. The minute entry reference? Is your position just that because the trial court disagreed with you, he must not have considered the affidavit? Or what is the language that says, I didn't take it into account?
So in the minute entry, it states that the only basis articulated in defendant's motion that might support relief was the medical emergency of Lisa's mother. And then it goes on to say, but, quote, defendants did not provide any evidence of this apparent claim of abuse or excusable neglect with their motion. It is only in the reply, end quote. So then the court goes on to decline to present any analysis on the issue or rule regarding whether that issue that the court raised that they said may represent a basis for a new trial and setting aside the judgment whether or not that would actually do so under the affidavit. So based on that language in the minute entry itself, the trial court could not have considered the affidavits. It did no analysis. It said that this may be a reason, and then it declined to rule on that reason.
But it was an abuse of discretion not to consider, your argument, an affidavit submitted in a reply brief.
Yes, Your
I
Honor.
mean, we can talk about whether or not that's even appropriate. I don't think it is. I think a reply brief has its place. It is a reply with response. Everything in it has to be responsive to that which follows. Unless, you're saying your colleague has to move for a surreply, just sort of as a matter of course when the reply includes additional evidence, that doesn't make sense to me. But putting that aside, whether it's appropriate or not, here, your argument is that it was actually error for the court not to consider evidence submitted on reply. Do you have any case law or rule that says that is something that must be considered?
I don't have case law that specifically says that a affidavit in a reply must be considered. However, based on the fact that the courts have held that there's a desire that cases should be resolved on the merits, the court said, and I apologize, Your Honor, I'm just trying to find the specific quote. The court did say that essentially tie goes to the person looking to set aside the judgment. And our position is that this was essentially a default judgment, even though the actual method was a Rule 56 motion. And if Your
So
Honor,
how far does that preference to resolve on the merits go? I mean, do we sort of look at the rules as aspirational? And if you're close, we're going to let you have another chance? Or I mean, how is that an applicable, firm source by which to run courts?
I'm not sure that it would be a firm standard. It would be something that would have to be, examined on a case-by-case basis. And I think...
Well, here we have a reply brief with evidence, and the answer to that is we want to resolve on the merits, and we have a lawyer who made misstep after misstep and malpractice all the way through judgment. And again, the argument is, well, we want to resolve on the merits. So I think it's a significant issue given that it's the common thread here.
Absolutely. I think that there is obviously a conflict, which the court cases have recognized, that there's a conflict between wanting to try cases on the merits and also having a type of surety based on judgments. Here, there was no discovery, there was no disclosure, and quite frankly, this isn't a prejudice to plaintiff. It's a lot like when you wake up and you find in your bank account $56 million, and then the bank tells you, look, this is actually a banking error, they take it away. That's disappointing, but that money was never yours to begin with. Here, it's much the same. Plaintiffs are not prejudiced because the the judgment never should have gone through so quickly in the first place. There should have been discovery. There should have been disclosure. And certainly they might eventually be successful. We don't believe that they will. However, we believe that based on the circumstances, they warrant the reversal of this decision, and at the very least, the trial court should consider the affidavits in deciding the motion for a new trial. And if I might reserve the rest of my time for a rebuttal.
Sure. Thank you, counsel. It's Mr. Ryan?
Yes, Joe.
Thank you, Mr. Ryan. Okay, let's hear from...
Good morning, and it may please the court. My name is Jason K. Thomas, here on behalf of Plaintiff Appellee National Sign Fabricators, Inc. and Bonus Investments, LLC. I think what we heard counsel here describe was an untenable standard, a standard that he's unsure of. But if we look to Rule 59, and in the discussion of irregularity, it is really irregularity of the opposing party or the conduct of an opposing party's attorney that causes irregularity or that harms the proceeding of the trial or some way it materially impacts the other party. And that error of the opposing party or that irregularity bleeds over into the decision or the judgment.
What would you say is the best case that tells us that the irregularity must be by the opposing party or the opposing counsel? Or is
Your
that
Honor,
in
I
the
think
rule?
King v. Superior Court 1983 leads this court to that conclusion. And if I may turn to King for a second.
Well, go ahead and answer.
So in King, they are looking at a malpractice claim against an attorney. And what happens in the lower court is there's a declaratory judgment action, and the action is bifurcated. First, they're going to say, is there a partnership in existence? And then they're going to move on to the second half of the trial, which are other issues. In that first part, apparently, King loses. A partnership exists. However, apparently he learns sometime after the fact that his attorney was participating in some sort of settlement discussions. And that upsets King. He fires his attorney, and he files a motion for a new trial. And in that, he says, essentially points to this conduct of his attorney having somehow impacted the jury's decision that a partnership existed. That his motion for a new trial was denied, and he turned around and filed a malpractice claim against his attorney. He apparently filed two similar cases. They went on different tracks, different judges. Both dismissed, both dismissed the action. And then on appeal, they were looking at what he could do here to save it. And they're looking back at the lower court, and they're looking at it for a preclusive effect. Did he make all of the arguments in his motion for a new trial, and were they actually tried on the merits there, thus precluding hearing them again in the malpractice claim? And the court, in kind of dealing with this, is looking at what happened below, and they're saying, they don't really like this idea of going after the attorney in the same case, and then those arguments on a motion for new trial precluding the actual malpractice claim that comes later.
Counsel, let's say, not on the reply brief, but on the underlying motion, your colleague had attached a notice of disbarment from this counsel. Is that enough?
I'm sorry, Your Honor. Is that enough to what?
Well, we're talking about what, setting aside Rule 59 and 60. So what was the motion titled that the reply was? Was it a...
The motion, it was a motion for a new trial.
Motion for a new trial, okay.
And motion for relief from judgment.
All right. So if your colleague attached to that motion, told the same story, but attached a notice of disbarment, would that result in a different holding?
Your Honor, no, I don't believe so.
Why?
Well, I don't know what this notice of disbarment might say, or if it pertains to these particular clients. What was he disbarred for?
Let's say something completely different.
Right, and I think that would cause a lot of questions. For instance, even outside of this context, if an attorney was disbarred, how would that impact some of the dozens of cases he has? Do they all get questioned at that point? And I believe the answer to that is clearly no, they don't.
Really?
The underlying actions and conduct and behavior of the case, they don't come presently at issue. Now, that attorney is going to be required to withdraw, but that doesn't mean that all of the conduct and actions he took on behalf of his client are immediately questioned.
But that's the point of the motion for a new trial, which is we have a lawyer who has not done his job, okay? And you're saying, so what is there any instance that you can conceive of that in that scenario the trial court should grant a new trial, where you have an incompetent lawyer?
Your Honor, I believe maybe if he had come to trial and had done something, outrageous or outlandish that prejudiced his client for proceeding in that
Like
manner.
conceded liability in an answer?
Well, now I believe that that's a difference of strategy. Counsel here disagrees with prior counsel's strategy, and if we were to actually look at the defenses they raised, we would see that the prior counsel strategy is probably better than the current counsel.
How about a strategy of not filing a response to summary judgment and not appearing at argument on it?
Your Honor, there was a response to the summary judgment filed here.
Sorry, not appearing at argument on it.
I understand. I think that was an ill-conceived strategy, but one
Well,
that they took.
you're sticking with it's a strategy.
Your Honor, I believe if we look at the affidavits, we have to conclude that this was the strategy. They only became
Let's talk
unhappy
about the
with
affidavits for a second. Setting aside the fact it was filed only in reply, which, like Judge Weinswag, I'm troubled by that. Your motion is to set aside a verdict, so the burden is on you at the time you file the motion to establish your evidence saying that it's set aside. So at that point, it's perfectly fine in response to say they've presented no evidence. I don't know that you can make that up in a reply. But setting that issue aside, what evidence is there to controvert the affidavit? I mean, it seems like we've got nothing on the record from you guys saying that there's anything else, and I'm not sure you could have provided anything else in this.
Right, we don't know who the lawyer is, and we were not able to impeach him. This was done in a reply, so there
And by
was
not
no
providing
rebuttal
your
to it.
name, you can't even go and take his deposition or get a statement from him or anything like that to rebut it.
Correct. And that leads me to the Panzine case that I've cited. And in there, they discuss California's difficulties with trying to implement something like this, where a party's own lawyer's misconduct may be grounds under their version of Rule 60. And in there, that started at common law, and then they've modified it most recently in a 1988 amendment, I believe the most recent is 92, but prior to that, in 1988, they limited that to default judgments only. And then they also required that the attorney provide a sworn affidavit attesting to his mistake, inadvertent surprise, or neglect. And that's the requirements to set aside a default judgment in California under this rule, where it specifies.
Doesn't your colleague say you did know the identity of the lawyer?
Your Honor, as I stand here today, I still do not conclusively know who it is. I have an idea of who it is.
So that adverb conclusively threw me.
Not a fan of LY.
If we take out conclusively, can you still say that?
Absolutely. I don't know who he is for sure. Sorry, conclusively, I don't know. It's never been stated. Now, in the reply brief is where it's most clearly relayed to us that it was, in fact, the prior bankruptcy counsel. And we know who that is from the pleadings in that case. We filed claims in that bankruptcy. So we do know that person's name. We don't know if that was the relationship that they were discussing prior. And this comes from communications prior to filing the complaint. We were contacted by other potential counsel for the Millers who apparently didn't take up their case. So there was several lawyers that we were aware of that may have been working with the Millers. The fact that it was their actual bankruptcy counsel, it's never been stated, for sure, that that's who it was.
And that's important because it is that individual's well, I don't want to say malfeasance, but incompetence.
Alleged malpractice.
Alleged malpractice that provides the foundation for your colleague's argument. Is that fair?
As I understand his argument, yes, Your Honor. I would also like to discuss a point he brought up about prejudice, which goes to finality of a judgment. This case didn't come out of thin air. The money that was awarded wasn't something that the judge just made up after the summary judgment. There was real damage to my client. He lost his life savings in the sale of his small business, and that's what that summary judgment was about. The fact that they answered the complaint admitting liability was not a surprise to us, given the information we had collected in the bankruptcy, and that was our impetus to file the motion for summary judgment. When we talk about efficiently resolving disputes between the parties, this is exactly what a summary judgment motion was meant for. At what point do I, as counsel, receive an answer, have all of this other information from a prior bankruptcy, and then have to question whether it was poor strategy of their counsel to admit what I believed was validly admitted, and to deny and preserve claims about maybe the amount of damages. Maybe they did have something there.
You
put
said
that to the
something
test.
there that gave me some pause. You said
Yes, Your Honor.
rely on the strategy of prior counsel. They filed it as pro pers, right, the answer?
Yes, Your Honor.
Okay.
Well, and I say that here after the fact, not knowing who had written that. But at that time...
I mean, there's allegations that someone ghost wrote it for them.
Sure,
Yeah.
sure. And the point being is, when is an answer an answer? Even if you decide that a new trial is warranted, what do we do with that prior answer? At what point, when somebody answers, you get an answer, you have what you need, they're contesting damages, you move for summary judgment, which would be absolutely appropriate use of that mechanism, and then they respond to it, essentially admitting liability again and contesting whether we mitigated. We overcome that, and it's still, we shouldn't have relied on any of that, because apparently prior counsel was in the background. Now, what the affidavit said is that was their strategy, was to delay these proceedings, to thwart efficiency of resolving these disputes. That was the reason he did not make an appearance. And the Millers, for better or worse, did agree with that. They liked the idea of slowing this thing down, and they went with it.
What about your colleague's argument, which is a very fair point, that we want to resolve things, cases, disputes on the merits?
I think that is a high goal of the judiciary and of all practitioners. We should try to get to some idea or understanding of the truth. Here he's saying, oh, we didn't have discovery. Discovery for what? They said Mr. Bonus came onto the property and harassed them. Mr. Bonus didn't give them a notice. Mr. Bonus didn't pay them for storing personal property. What discovery were going to elucidate those claims anymore? If they had those defenses to bring, they should have brought them. And the time to do so was at the motion for summary judgment stage after having admitted liability. And they failed to do that. And to the extent that they really blame their prior counsel, they have a good claim against him if what they said is true, is true. But I don't know that, and my client shouldn't have to bear the burden of redoing this thing on a new attorney's strategy once the first attorney's strategy failed. And if you don't have any further questions for me.
No, thank you very much, Mr. Thomas. Okay, Mr. Ryan.
Thank you, Your Honor. I don't think that answering, and admitting liability, summary judgment, I don't think those are strategies. It's deliberate misconduct, and I think that it's interesting that the attorney who did these things profession is a bankruptcy attorney, because that is what the judgment is pressing my clients towards. Certainly, these are unusual circumstances, and certainly this is not for every case that we overturn a motion for summary judgment. But based on the facts of this case, I believe that they should.
What would we do here if we granted your client's relief? So we set aside the summary judgment grant. Wouldn't we also have to vacate the answer?
I believe that I would have to amend the answer, Your Honor. Yes.
Okay.
And certainly it's not for every circumstance, but there was discovery that would have affected my
And
client's
let
claim.
me, I'm sorry, I'm hung up
Go
on
go
this.
ahead, Your Honor.
And the answer was prepared, it might have been ghostwritten, but it was signed by your clients.
It was signed by my clients, not that they understood it or understood, the implications of what they were signing. They certainly believed that
But
they
it says
were.
things like, we admit paragraph 1, we admit paragraph 2.
It does, Your Honor. That is true. And it was signed by my clients at their attorney's request. As for the discovery, there certainly is discovery here that could be done. There are prior employees of the company. They also did not own the company completely on their own. There were other owners that also would need to be deposed and questioned about potential breaches and these things. But essentially, Your Honor, this case comes down to the Millers were not treated fairly in the legal system because of prior counsel. And that's not, opposing counsel's fault. I understand his position. But at the end of the day, this judgment never should have been entered. There should have been discovery. There should have been disclosure. And then after there were facts, the case should have been decided. That's not a high goal. That's the main goal of our legal system. There's nothing further on in my argument here.
Okay, well, thank you
Thank you,
both for your argument. We appreciate it. We will take it under advisement, and with that, we are in recess.